Good morning. I'm Tom Mealy. Welcome to Legal Straight Talk. It's Saturday morning, 9 o'clock. This is the premiere of this show. Each week we are going to be interviewing several people. We're going to be talking about the ins and outs of the legal community, what you can do, what you can't do. If you're involved in certain circumstances that you require a lawyer, the question is going to be, do you need a lawyer? How expensive are lawyers? And is there a way to take care of whatever problem you may or may not have by yourself? And this morning, it's my pleasure to introduce the host of Legal Straight Talk. It's the Harrison Law Group with attorney Brett Harrison and attorney Richard Coleman. Welcome, guys. Good morning.
Good morning, Tom.
Morning, Long Island. Good morning, Tom.
Oh, here he goes.
I am wrought up and ready to go for another great series.
Well, listen, guys, as you know, a lot of people on Long Island always have the question in their back of in their mind, do I need an attorney? What is the attorney going to do for me? If I hire him, how much is it going to cost, et cetera, et cetera. There's a million different things that, that goes through somebody's mind. And the biggest problem that I have is that people, let's face it, guys, people have a misconception of lawyers. There are good lawyers, there are bad lawyers. There are good politicians, there's bad politicians. So what separates you from the difference between a good politician, a bad politician, a good lawyer, a bad lawyer? What separates the Harrison Law Group from that?
That's an easy question. We talk English.
Explain a little bit more.
We take out the legalese and we try to explain it to you the way we understand that you're not lawyers. Just like if we came to a mechanic and he starts talking to us about Fetzer valves, this and that, I don't know what he's talking about or she's talking about. I want to know, why doesn't my car work? Explain it to me. My car has a cough. My car has a hiccup. So when we talk to you about, instead of saying, this is your no fault, we don't use the legalese. We translate the legalese into English. So A, you feel comfortable. You understand where we need to be at the end from the beginning. We take you step by step. We keep you informed. But more importantly, we ask you a little bit about your life to understand where you need to be and what your concerns are, be it personally, individually, or for your family, work-wise. There's a lot of different steps, but part of it, a lot of people have problems with lawyers is because they're not listening. They don't take the time to understand them. They treating them like they're file number 161. In our office, you're not file number 161. You're person Tom Mealy or your person Joe Smith. And that's people need to have a comfort level with attorneys. And I think that's the advantage of us. And we try to personalize it by having you assigned partially to a paralegal that understands you, that knows you, that stays with your case from day one till the end.
Well, that's good. Some of the biggest questions people ask me when they need an attorney is, I don't understand what they're saying. And I tell you, another problem that we have with lawyers is a lot of people out there are very intimidated by an attorney because they know that an attorney can speak one way, but in reality, in the world of law, it could mean something completely different. So you're telling me that when a client comes into the Harrison Law Group, you're not going to do that. You're not going to say one thing and actually mean something. You're going to give them the straight scoop. You're going to tell them how it is.
No, we're going to give them the straight talk.
Okay.
Maybe we'll cross out the legal and put the English straight talk.
So you're not going to, in other words, you're not going to BS these people. They're going to come in. You're going to want them to trust you.
We're going to want them to trust me and understand. Like them, we weren't born with a golden spoon or silver spoon. We understand their needs. We understand that they can't, if it's a non-personal injury case, that they just don't have an open wallet. Right. That they have concerns too. You got to look at, you have to look at each case from their individual standpoint, their family standpoint. And one of the great things, at least for me, is I have Rich a lot of times to bounce ideas off of. He's the elder statesman in the group.
Well, I've been practicing 33 years, almost 34 years, so I've seen it and done it pretty much. But when a client comes into the office, the most important thing, as Brett said, is to have a comfort level with the client. First of all, in a personal injury case, A client wants to know, what am I going to pay the lawyer? What's this going to cost me? Do I have to reach into my pocket? And the answer is no. In New York State, where we practice, in order to handle a personal injury case by law, the attorney can only take the case on a contingent basis. What does that mean? That means that you don't pay us a dime unless we're successful in your case. If there's no recovery, there's no fee.
So you're saying then, Rich, let's just put it into plain English for people. Basically, listen, if we take your case, pretty much we think we can make some money because the law is a business, but at the same time, you're not going to have to pay us. You don't get paid until we get paid. So you have a financial
but you know what?
interest.
There's a problem with that, and I got to be honest with you. You know, I've been in this business almost 30 years. I have seen it, and correct me if I'm wrong, Rich, because this comes up from time to time.
Sure.
I have seen other law firms, when they have taken on a personal injury case, the client signs the agreement, and then all of a sudden the attorney drops the case for whatever reason. Either he's not capable of handling it, or he doesn't understand the fundamentals, and then sends them a bill and says, listen, I've paid for A, B, and C. You need to now reimburse me for that, whether it be medicals or something. Why do some attorneys get away from it? And two, is that legal to do?
Yes. As I mentioned before, we're only permitted, lawyers in New York State, to handle a personal injury case on a contingent fee. That means, again, that the client does not pay us anything unless we are successful and get a recovery for them. However, by law, the client is responsible for any legal expenses. However, at the Harrison Law Group, we like to take cases we feel we have a reasonable basis for getting a recovery for the client. Because at the end of the day, what's the sense of taking a case for a client to turn around and ask the client, we didn't get any money for you, we don't get a legal fee either, but you owe us $800 for the expenses that we had in processing the case.
Well,
it's not good business.
When you say expenses, why don't we clarify that for people? People don't know, that sounds, what's an expense? What kind of expenses can they anticipate having to pay or reimburse, or that the Harrison Law Group will lay out, or that will lay out?
The expenses that we can charge a client, or that the client's responsible for, are expenses that only we can charge legally. For example, let's say the client comes in and we have to hire a private investigator to get statements from witnesses at the scene of the car accident, to go out and make diagrams, take photographs of the area. And then the investigator who we use sends us a bill. Well, we pay for that. And at the end of the case, that is an expense in the case. But that's a legitimate expense. It helps the client. It helps process the case.
So it's necessary for the case.
It's necessary for the case. Another example, Brett, client should know, for example, if we're unable to resolve the case and we have to put the case into a lawsuit, there are many expenses that we have to pay, and ultimately the client shares in that expense, to process the case through the court system.
Meaning, so you're saying then that money doesn't necessarily go to the law office. It's an administrative expense. For example, to purchase an index number to get into the courthouse.
Oh, then let me ask you a question, because I'm going to cut you right off at the knees then.
Sure.
So what you're saying, and what our viewers are going to hear right now, is that if they come in, and listen, I firsthand know the abilities of this team. So what I'm going to say is the odds of it actually happening are probably slim, very, very slim. So let's assume, Brett, that we take in a case, all right, and for some reason we can't do this case, so this case is definitely unwinnable, but yet we've exhausted, let's say, $40 in expenses. Are you saying then at this point that the client is not going to be held responsible for that $40?
Exactly. We personally, we will never, as a law firm, ask them to reimburse us. That's the risk. We call it our own risk. We based on our experience, we figured, we could resolve this case. We thought it might be a case that everybody could benefit, but only through investigation and time, we realized, it's not a case that's winnable for whatever reason, whether it be liability threshold, which we'll get into at another time. We decide it's not a feasible case that can be won.
All right. So, and again, just to
Or settled.
recap, client comes in, client has a personal injury case. Let's assume at the end of the day that this client actually caused the accident. A lot of people don't understand that. We will get into liability issues later on in the show. But this client comes in and the case is unwinnable. The Harrison Law Group has dispersed $50 in expenses by obtaining certain information. We can clarify right now, undoubtedly, that they will not be held responsible for any money out of the pocket of the Harrison Law Group.
The only thing I may add to that, Tom, is legally speaking, and the requirements of the law, is that the client is responsible for the expense. However, we make a business judgment in our firm that if there's a expense, as you mentioned, $40, $50, $60, $70, $100, although the client is responsible, our firm will absorb that. But
That's what we need
technically,
to know.
under the law, the client is responsible under a contingent fee retainer for any expenses that the attorney incurred. However, we take the position that those type of expenses, those type of numbers, unfortunately, for whatever reason, we will absorb it. The client walks out of the office with not putting their hand in their pocket at all.
Great. Okay, you are watching Legal Straight Talk with the Harrison Law Group, located in Massapequa, New York, with satellite offices in Suffolk County. We're going to cut to commercial. When we come back, we're going to talk about the fundamentals of what happens when you're involved in an accident. What is the first thing that you should do, who you should talk to, and who you shouldn't talk to. We'll be right back after this. You're watching Legal Straight Talk here on the Madhouse.
Having problems practicing at home? Not enough space for everyone? Are neighbors giving you problems over sound levels? Then come down to Long Island's #1 music rehearsal studio complex today. Phase 1 in Farmingdale, New York is your place for band practice, open jams, auditions, and recording sessions. For over 25 years, Phase 1 has been the home of countless bands of all styles who develop their musical acts right here. Our highly affordable, state-of-the-art equipment, immaculate spaces, and professional service are always available to meet your musical needs. Phase 1's well-managed, soundproof studios guarantee the highest level of privacy, allowing you to explore your creativity with zero interruption. Are you ready to showcase? Then check out Phase 1's 1,500 square foot super sound stage, complete with all concert quality amps, drum sets, sound engineering, and professional lighting to accommodate you and all of your guests. So, whether you're ready to take your show on the road, or you just want to jam with your friends, then come on down to Phase 1 Sound Studios, where music begins.
This is Tom Mealy for 1-800-INJURY-LAW, and I'm going to get right to the point because you know what? When in an accident, there is no time to fool around or waste time going to firms that say, if it's not broke, there's no case. Soft tissue injury is no joke and can last longer and feel worse than a fracture. And if left unattended, you are looking at a lifetime of trouble and or pain. You are entitled to compensation. Listen, most of us on Long Island, we weren't born with a trust fund or a silver spoon in our mouth. Don't let someone tell you that it has to be broke or you need to be out of work to compensate for an injury sustained by someone's carelessness. The number you need to call is 1-800-INJURY-LAW, the Harrison Law Group. That's 1-800-INJURY-LAW. Listen, take my word for it. We're not in business to lose. We're here to protect your rights. 1-800-INJURY-LAW. Injury Law.
Welcome back to Legal Straight Talk. I'm Tom Mealy. I'm here with Brett Harrison and Rich Coleman, the two senior partners with the Harrison Law Group located in Massapequa, New York, with, again, satellite offices in Suffolk counties for your convenience. You know, before we left, we were talking about some of the issues that a client can expect when a client comes into the office who's been involved in some sort of an accident, whether it be a slip and fall, a motor vehicle, or whatever would hurt you at somebody else's negligence. And at commercial, Rich was mentioning to me about the amount of experience that this firm has. You know, to say that you have a combined experience of over 50 years, that means you have seen everything. You have seen, maybe not 90% of the transition from 50 years of heavy experience. And with experience, you know how to go to the mat. You know how to take this case from start to finish and get the largest possible settlement that you can possibly get in any motor vehicle or slip and fall case or accident case for that matter. And that's what we do here. And we're going to talk to Rich a little bit more about this. Rich, when you say we go to the mat for these people, and you know, a lot of people, they don't quite understand what that means. When we go to the mat and we take this case down the road, exactly what does that mean and what can a client expect?
Okay, when a client comes into the office, what's important to us, and I've been doing this for many years, is to really explain the whole case to the client. Not only what we've been talking about the contingent fee, but basically what to expect in their case. Because obviously they're hurt, whether it be an automobile accident, whether it be a slip and fall, trip and fall, a construction accident, a defective product, whatever it may be. So the client is anxious, the family members that many times come into the office with the client, what's going to happen here, what can we expect?
Like a table of contents.
Basically,
with a timeline.
Correct. Right. Now, not every case that we handle, and I've handled and Brett have handled over the years, ultimately settles. Most do, and that's the profile of most cases. However, some cases, because of the type of case, because of what happened in the accident, because perhaps the significance of the injury, we may have to take that case to court. And what we tell the client is, more often than not, most cases are settled. You may have to participate if the case is in a lawsuit scenario where you're going to have to testify at a deposition.
Well, Rich, you know, I understand that, but I think what some people should understand is it's not hard to take a case to court, but where the experience comes in is positioning it to go to court, positioning it to be successful. And that's where this isn't our first time around the rodeo. So
we've done this many times. I've tried many cases, and what I was indicating was if the case needs to be tried, we will go to the mat for the client. I will see the case, we will see the case through, try the case before a jury, do what we need to do aggressively for the client to get the maximum recovery we can.
As a let me just interrupt you. As a non-attorney, you know, people don't understand what the difference between, and most people do, but a lot of people don't. I found in my career that when they say, are you going to take on my case, they automatically think that this is going to go in front of a jury trial or have a jury trial. That's not what it means. When the Harrison Law Group takes in a case, even though we don't take too much guff from the insurance company, correct me if I'm wrong, Brett, when we take in this case, we manage this case for the first 90 or 120 days. After 90 or 120 days, at that point, we know definitively, is that case going to go into suit? Now, the statute of limitation is 3 years to put a case into suit, and I want you to explain what the word suit means. But understand that a lot of law firms that handle personal injury, they'll wait until the statute is run, which is a 3-year statute, all right? But here, we don't do that. No. In 120 days, let's get to the bottom line. If the insurance company pisses us off, We're taking this case, it's getting filed, and it's going into litigation. I want you to explain the process.
Well, let me explain a little bit more about what we were talking about in the beginning, where we get to know the clients, we get to understand the clients, we actually meet the clients. Some attorney firms don't even meet the clients. They couldn't identify them in a lineup. And that, I think, is a fatal mistake, and I think that's based on our experience that, you know, you as a client, you don't just come in, sign a retainer, and say, now it's up to you to do. You know what? You have a responsibility too. You have a responsibility to act, I don't know how to say this. You have a responsibility to the case too. We're sizing you up as well, saying, well, look, is this a case that we want to take all the way to the mat? Do we need to, if we go to trial, if we do depositions, can this client handle it? Does this client understand the responsibilities that's going to happen with a deposition? Can they answer a question? Can they sit? Can they listen? Can they handle, there's a certain amount of pressure that they have to look at too. So they have a responsibility to the case as well. Rich, I'm going to let you explain that a little bit more.
Okay. When we know that a case has to go into a lawsuit, you know, we advise the client, let the client know, look, the case can't get settled for whatever reason.
Or there's an offer on the table, but we, you know, as an obligation, any offer, whether it be small or large or whatever.
We will advise the client. We don't hold anything back. If the insurance company offers $1, we advise the client, look, there's $1 on the table. We advise you, don't accept it. We feel we can get more money for you and maximize
based upon
recovery.
Experience, based upon, we look at who's the, you know, this is where I'm going to talk legally, the straight talk of it. We look at who's the other side. Which insurance company is it? Because we know they have reputations. Just like each reputation is different. It may be the same case, but you got to think of it like when you were growing up and you wanted to borrow $25 from a family member. For me, the first person I'd ask is my mother. Why? Because there's a better chance, her reputation is that she would give it to me a little easier. Where the last person I'd ask would be my father, because I'd have to go through why I need it, and in the end I wouldn't get it anyway. Well, each of the insurance companies has a general reputation as well. And that comes, and understanding that, and understanding the trends of what that insurance company is doing is, and which ways they're going, is based upon our experience, based upon handling hundreds of cases, and seeing where they're going. But having said that, I'll let you...
Well, wait. Let me just back up for a second with that. So in other words, you know, and obviously we're not going to name carriers on the air. We can't.
And it's
do
only
that.
a generalization.
But let's take two carriers in general. We know that carrier A, all right, it could be a real pain in the neck. We know that carrier B is very likely to resolve the case.
More reasonable. Why don't we call them more reasonable?
So let me ask you a question. Carrier A, who's the difficult one, that case comes in. Is it more likely that we're going to throw that into litigation and take it to the next level quicker than carrier B? The answer would be yes.
Yes,
but we also explain that. That's part of our table of contents explanation that we talk to the client about. You know, say, listen, this carrier is who's on the other side, generally based upon our experience handling hundreds of cases with that carrier. We found that the only way to get their attention and to reasonably resolve this case is we're going to have to, for example, I just put a case into suit after 6 days when we got the case.
Right, but you know, and I need people to understand that some law firms that have not been doing this for a long period of time, it becomes a financial issue. When you put a case into litigation, you have to spend money on that case. There's an index number, there's an RJI, which is we will get into later on. There's process serving. A lot of law firms don't want to do that because that's money out of their pocket. Got to understand something about us or the group. We don't need to settle your case to make the payroll. So that means that we have no problem if carrier A is going to be a pain in the neck, and we know that up front, that case is going into litigation, and we're not going to question the money aspect of it. It's going in because we know that the faster it gets in, the better it is for you, and at the end of the day, we don't have to wait 3 years to resolve this case. We move it through the trial process, and these companies have either two things they can do. In my opinion, they can pay us now, and hopefully that we settle the case, or they'll pay us later. That's my reaction. You agree with that?
Yeah, and by pain in the neck, you simply mean they just put up constant roadblocks, and to get their attention, sometimes you have to go further with the case and tell them, listen, you know what? Kiss off. We're going to keep going further with this. We're not afraid to challenge you. But however, one thing that we do in this office, as opposed to some other offices, those cases that we're going to take to the mat are ones that we're not only confident we could win, we're pretty certain. We're not taking these, well, I don't know if things go right, maybe the carrier would be willing. We want to put them on their backs, put them backpedaling. That's
right.
What we need to do.
Brett, we have a few minutes left here for the show, and I just want to close up in saying that next week we're going to get into the actual heavy fundamentals of when somebody is involved, what they should do, what they shouldn't do. In the next couple of minutes, you have anything that you'd like to end with, Rich? At this point, you have anything that you want to close with?
I think that what a client needs to do when they're deciding who to bring their case to is what's important is the experience, the comfort level, the qualifications of the lawyers, the staff that the lawyers bring to assist the client. We have everything at the Harrison Law Group to make that work successfully. We've been doing it for a long period of time, both together, Brett and I, and individually.
He's much older.
A little bit older. So I think at the end of the day, when a client decides to make a decision on hiring a law firm, they should consider the Harrison Law Group and move forward and sit down with us and discuss the case with us.
Brett, in closing, you're the senior partner here at the firm. Any words of wisdom to the clients?
Yeah, I mean, take seriously who you have as your attorney, and understand that you're the general in the case. We're just the soldiers carrying out the task. You're ultimately going to make decisions, but your decisions are only as good as the information and the people that are giving you the information and showing you the different options. And that's what we're here to do, is just tell you straight up what are my options, what are the good, the bad, and the ugly in the case. And there's good, bad, and ugly in each of the cases, unfortunately. And our job is to show you the different options. But also understand one of the important things that separates us, I think, and a common complaint that I see from clients about other attorneys, why they switch to us and we substitute them quite often, is, you know what? I've had the case 1.5 years with this other law firm, and they never call me, they never contact me. We keep you informed consistently via letters and also via telephone conversation. Also, a lot of times clients come in and we go over their case. And that's important, communication.
Okay. Well, thanks, guys, for coming on.
Thanks, Tom.
And
Thank you.
You're watching Legal Straight Talk. It'll be here every Saturday morning, 9 o'clock here on the Madhouse. You can also re-see this video by going to the Harrison Law Group on YouTube, as well as Madhouse TV. You can look at the website, the Harrison Law Group website, which is in the process right now of being modified and should be online shortly. It's the HarrisonLawGroupLI.com, HarrisonLawGroupLI.com, or you can contact the Harrison Law Group directly at 1-516-390-0808. You're watching Legal Straight Talk. Thanks for watching. We'll see you next week.